Good afternoon and welcome to the Barnes & Thornburg Policyholder Insurance Recovery and Practice Group webinar entitled Management of Insurance Claims. My name is Ken Gorenberg, a partner in the Chicago office of Barnes & Thornburg. I'll be serving as your host and moderator today, so I will give you a few housekeeping items to keep in mind, and then I'll begin introducing our speakers today. And we have three fine speakers from three different offices of our firm. After the presentations today, you will receive an email that will include a copy of all of the presentation slides, as well as a survey that we would really appreciate you taking a few minutes to respond to so that we can get a better idea of how we're doing and what more we could do to serve your needs as our prospective clients, current clients, prospects, and just interested parties. In connection with all of that, you will also get information about obtaining your CLE credit. It's already been approved for Indiana and Illinois. Other states will also be handled subsequently. On your screen, you will see right now a picture of the smiling face of my partner, Adam Hollander. That's not me. My name is Ken Gorenberg. But on the right of that picture of Adam, you will see a Q&A box. Feel free to type in a question there at any time, and we will either take that question on the fly during the course of the presentation, or we will take some questions at the end of all three presentations as well. You may also feel free to save all of your questions till the end. We really do encourage you to ask as many questions as come to your mind and to keep this as lively as we can. Another thing that you will see pop up a couple of times along the way, probably just between the presentations, is you will see a box show up on your screen asking you to click yes, that you are still attending and listening and paying attention. And that is for those states that require confirmation of your attendance in order for you to get your CLE credit, which I know is very important to all of you. And before we begin, just a couple of other references for us and our practice group here. You can find the entire firm and information about us at BTLaw.com. Our practice group also hosts a blog where we publish things at least once a week, and that is BTPolicyholderProtection.com. We would encourage you to enroll in a subscription to that, which is free, and you'll get an email every time a new post is put up on that blog. We also have a very good presence on LinkedIn. And now, without further ado, I'll turn to our speakers here. As I said, this seminar is entitled Management of Insurance Claims. Those of you who've had the opportunity to participate and listen in to some of our previous webinars or even our live seminars may recall that we've done some pretty deep dives on substantive insurance coverage issues in prior sessions. Today, we're going to take a step back and try to provide some more practical nuts and bolts ideas that aren't necessarily tied directly to a given substantive area, though you will see some substantive information covered as well. So here in Chicago, as I said, is my partner, Adam Hollander. Now here in Chicago, it being springtime, we're all very excited that the Bulls and the Blackhawks are in the playoffs. Neither baseball team has been mathematically eliminated yet. And we have the NFL draft actually coming here to Chicago later this week. And so in that realm, I thought it would be worth you all knowing a little known fact about Adam. This past year, I actually drafted his fantasy football team for him. And the result was I gave him a better roster than I gave for myself. So, Adam, please take it away.
Thanks, Ken. Ken didn't mention that I think I finished out of the playoffs with that team, but it's a story for another day. So, anyway, thank you all for coming. As Ken said, my name's Adam Hollander. I'm a partner here in the Chicago office of Barnes & Thornburg. I want to thank you all for coming and joining us today. I know that time is a precious commodity for all of you, so I appreciate you all signing on to listen to us lather on about insurance for an hour and a half. Just a tiny bit about myself. For the last 20 years, I've been practicing 100% in insurance recovery, assisting policyholders in their recovery efforts. Today we are going to spend just a little bit of time talking about a subject that is near and dear to my heart, which is choice of law consideration in the insurance claim and recovery context. I find it very interesting that it's such an important topic and such an important consideration, but many people still just don't realize that choice of law analysis can be one of the most singularly important projects to be undertaken when parties sit down to talk about managing their insurance coverage claims and ultimately preparing those claims for litigation. Any kind of coverage claim, whether it's an environmental claim or a just run-of-the-mill bodily injury claim, a D&O type of claim, E&O type of claim, employment liability claim, they can have any number of different state contacts. Any number of different laws or states could have interest in the litigation, and there could be any number of forums that could be potentials for a policyholder to bring suit. Now we'll move on so you don't have to see my face staring at you anymore. There's all these different possibilities. You've got, hold on, let me grab the little pointer here. Of course, you've got where the policyholder is located. You've got where the insurer is located. You've got the state where the underlying injury or damage occurred. You've got the state where an underlying lawsuit could be filed. You've got a state where the policy was delivered. And basically, you've got any other state that's out there that has any kind of meaningful connection to the claim. Where a broker is located that has significant involvement in the negotiation or the placement of the policyholder. You could be a subsidiary of a parent company that's located in a different state. So the upside of this is that in any coverage claim, you've got a number of different states and possibilities for purposes of choice of law. But just because you have all these forum options, it doesn't mean that each option is actually well suited for your coverage case. Indeed, as many of you likely already know, the law on many of the key coverage issues that we face all the time, and these are issues that could actually be outcome determinative of your case, these laws are going to vary widely from state to state. And also, the choice of law rules can vary just as widely depending on which state you litigate in. So it's really critical that at the outset of your claim, you determine which state is going to be the best state for you for litigating your coverage issues. Because choosing the right state, or the wrong one for that matter, can really mean the difference between prevailing on your coverage claim, getting the money that you so rightly deserve, or having your case thrown out on summary judgment and coming home empty-handed. So the following slides are going to show just a few examples of how different states treat some of these critical coverage issues. So, for example, it shocks me, but late notice is still something that happens all the time in coverage cases. You have an incident that happens in 1 year, and you don't think anything of it because you think that it's just going to go away. It wasn't significant enough, and sure enough, a year or so later, somebody brings suit and becomes much more, your exposure is much more significant than you otherwise would have thought. This is a big issue, and it remains a big issue, and carriers, rightfully so, because it's written in their policy that notice shall be provided within a certain amount of time or as soon as practicable or immediately in some instances, they will raise this as a defense to coverage. Now, some states are more policyholder friendly than others when it comes to this issue. Some states will say that, okay, well, notice may have been late, but unless the carrier has suffered any kind of real prejudice, it's really not going to provide a basis to let that carrier off the hook. Other states, Illinois is one of them, say, you know what, the policy says what the policy says, and the insurer need not demonstrate prejudice to get out of its coverage obligation. So some of the states in which prejudice is a factor and is a good state or good states for the policyholder, they include, as you'll see on the slide here, California, Connecticut, Florida, New Jersey, Oregon, Pennsylvania, Texas. Some of the bad states from the policyholder's perspective are Colorado, Georgia, Illinois, Nevada, New York, Virginia. And the Illinois analysis is that prejudice is just a factor to be considered when determining whether notice was unreasonably late. So this is an outcome determinative issue. If you're in a bad state for prejudice and for prejudice and late notice and you have late notice, you can be kicked out just on that technicality. Another issue that we come across oftentimes in the environmental context is the suit issue. A policy will provide not only is there a duty to indemnify, but there's a duty to defend lawsuits or suits. And some courts have taken that to be very literal. A suit is a lawsuit. And maybe if they're being generous, it also encompasses an arbitration. Other states say, well, you don't necessarily need a formal lawsuit, but some kind of compulsory process against the policyholder, like a PRP letter or a cleanup order or a notice from a state agency to get your act together with respect to an environmental site. That will suffice. So you'll see down below, I won't go through them all. Some states are good for the policyholder on this issue. Some states aren't so good. But the upshot here is that if you're in a bad state for the policyholder and you don't have an actual lawsuit, yet you still are incurring costs defending an administrative agency's compulsory action against you, you may not get coverage. So again, here's another instance of how states will vary on these very, very important issues. Yet another issue that we face all the time in the environmental context is the conditional pollution exclusion. These were exclusions that were put into CGL policies around the early 70s and lasted through the mid-80s. And they basically said that despite the broad insuring agreement, we're not going to cover you for pollution. However, if the policyholder can demonstrate that the discharge of the pollution was both sudden and accidental, then the exclusion's not going to apply, and you'll get coverage subject to the insuring agreements and the other exclusions in the policy. Now, as many of you I'm sure already know, there's been just a wide split of authority among the jurisdictions on how you should interpret these exclusions. Some of these courts are very, very favorable to the policyholder, and they say sudden does not mean sudden. It's got no temporal element. It just means a discharge that was unexpected or unintended. Other states read the exclusion literally and say if you need to show a sudden and accidental discharge, that discharge actually has to be sudden, something that happens abruptly in time, like a discharge from a fire or from an explosion or something like that. So if you've got a case with a leaking underground storage tank, if you're in a good state, that can be okay. The pollution exclusion may not apply. Because to the extent that you can show that the leaking was both unexpected and unintended. If you're in a bad state, you're going to be out of luck. Another one is the absolute pollution exclusion. After 1985, because the industry didn't like how the courts were interpreting the conditional pollution exclusion, they started putting in an absolute pollution exclusion. But of course, litigation ensued after that to try and figure out, well, what does that actually apply to? And there are some states that say, well, the absolute pollution exclusion will apply absolutely to any kind of pollution. Other states have held that no, you've got to read it in context, and you've got to take a look at the drafting history, and it's only going to apply to traditional environmental pollution. So if you've got a situation where somebody is claiming bodily injury because of leaking carbon monoxide, some states will hold that, you know what, that's not a traditional type of environmental pollution, and the absolute pollution exclusion will not apply. Other states say, hey, it's an irritant, it's a contaminant, it will apply. So again, this is yet another outcome determinative issue. I think the last issue that I'm going to raise here is allocation. This is an outcome determinative. It's not going to knock you out completely, but it could have a big impact on the value of your case. And it comes into play oftentimes when you have long-tail types of claims where you've got injury and damages that are spread out over a number of years. Policyholders like to have as much flexibility as possible, and so there's some states that give them that flexibility and say, well, you can pick and choose the years out of all the triggered years that you want to cover a claim. And other states say, no, we're going to take what they view as a more equitable approach and spread the damages out. The difference from the policyholder perspective is that maybe in some of these years you have policies with high deductibles, or they're fronting policies, or you may just not have any coverage at all. And the all-sum joint several approach gives you the opportunity to avoid those years and maximize your coverage. So here's just yet another example of what we've got. So now, hopefully, it's pretty obvious that depending on the issues that your claim presents, success in recovery can be completely dependent on having the right state's law control. Given that, we should probably take now a look at some of the different choice of law theories that are utilized by various courts throughout the country. And based on what I've presented so far, it probably will come as no surprise to you that there's also a lot of conflict among the jurisdictions about how to determine whose law should apply. But before we get started with this, I should point out just a couple things. And first, if your policy already has a choice of law provision, then, this analysis isn't going to really be all that applicable. And more often than not, that's not, that choice of law provision will control. These D&O policies that are issued through foreign markets, like the London market and Bermuda, and policies that deal with very specialized risks, those oftentimes will have a specific choice of law provision, saying that the law of UK or the law of New York or the law of Bermuda will apply. It's usually not the case in your standard general liability policy. Also, it's important to know that a court is going to apply its own choice of law rules, meaning that if you bring suit in Illinois, whether it be state or federal court, that Illinois court is going to apply the Illinois choice of law rules. Same for Indiana, same for Michigan, same for Wisconsin. That's just the way it goes. So, now, the meat of the matter. The very first and initial choice of law analysis is this Latin lex loci contractus. This is the traditional rule. This is the rule that most states used to use at the outset. And this one says that the law of the state where your insurance policy was formed or made is going to control. So if you're in a state that applies this rule, it's going to look to the law of the state where your policy was made and apply that state's law. So usually it's going to be the law of the state where the policy was delivered. And as you can see, this does not allow for much flexibility. Find out which law or which state the policy was formed in or made in, and bingo, that's what you get. So states like Alabama, Georgia, Virginia, and Maryland follow this approach. Another approach is the restatement second's most significant relationship test. This is a far more modern approach, and this one has been adopted by the vast majority of jurisdictions. So we'll see that each jurisdiction can have its different take on this and different spin on how they apply this rule. So here, the courts are going to look at a number of different factors instead of just one, like under the traditional approach, to determine which state's law is going to apply. So here they're going to look at the subject matter, they'll look at where the subject matter of the insured risk is. They're going to look at where the policy was delivered. They're going to look at where the last act giving rise to the policy took place, such as if a policy needs to be countersigned for it to be effective, they'll look at that state. They'll look at where the insurer is located. They'll look at where the policyholder is located. They'll look at where the policy is supposed to be performed. Where's the defense going to take place? Where are the indemnity payments going to go? And then as a catch-all, they're going to look at any other place that the court views and the parties advocate has a rational relationship to the policy. And as we saw in the very first slide, there's a number of different states that if we didn't already encompass or address them in these other factors, it could also have an important interest in the outcome of the dispute. So in my mind, this approach allows the most flexibility. You've got a number of different factors that you can argue have, little interest or great interest, and it gives you flexibility. It gives a policyholder the opportunity to argue for the application of any number of different states' laws, depending on the context that are present, and like that. So now we move on to, like I said before, just because different states have adopted this same analysis doesn't mean that they apply it in the same way. Illinois is one state that does apply the most significant relationship test, but it applies it in a different way from other states. So under the Illinois approach, if the insured risk can be confined to a single state, then the Illinois court's going to apply a special emphasis to the location of the insured risk. So think of like a property policy that insures just one piece of property. Say the property is located in Nevada. Just because it's an Illinois policyholder, that doesn't really mean a lot to the court. The court will say, well, your insured risk is in Nevada. That's the only insured risk there is. So it seems to us that Nevada is going to have the greatest interest in this dispute, and so we'll apply that law. However, that's usually not the case, especially when you're dealing with liability policies. And you have a policy that's issued to a policyholder that's got operations and exposures that are throughout the country or throughout the world. In that instance, the court's going to say, well, you know what, the location of the insured risk is going to be entitled to little weight, because in this situation, just by plain fortuity, you know, the coverage issue may deal with a location confined to a single state, but that doesn't mean that the next time it's not going to be in a different state, and the next time in a different state after that. So the courts will, in that situation, are generally going to default to applying the law of the state where the policyholder is headquartered, because in the court's mind, that's usually where the policy is delivered. That's going to be where there's performance. The policyholder generally pays premium from that state. It receives the benefits of the coverage in that state, and it's easy, and it's a good default rule for the court. And in the Illinois court's mind, it promotes uniformity, because what the court doesn't like in Illinois is to have an insurance policy that, depending on where the particular insured risk is, to have it governed by that state's law, because ultimately you could have 50 different policies covering the same policyholder. So they strive for uniformity. And in my mind, I think it's not a bad approach. Now, that's Illinois. You look at a state like Connecticut that also has adopted this restatement second approach, and under their analysis, there's just a rebuttable presumption that exists in favor of the state where the insured risk is. And regardless of whether the insured has operations in several states, if you've got a site that's located in Virginia, chances are a Connecticut court is going to apply Virginia law. If you've got a bodily injury accident that occurred in Mississippi, you're going to get Mississippi. If you have a D&O action, the majority of the bad or allegedly bad conduct occurred in California, a court in Connecticut, chances are will apply California law. So to overcome the presumption, though, and it can be overcome, it doesn't happen often, but if you can show a compelling interest and an overriding interest that another state has that's going to outweigh those interests of the state and the insured risk, a Connecticut court may very well deviate from its standard protocol. And then you've got the New Jersey take, which, again, is similar to the Connecticut take, but also far more parochial. If you're in New Jersey and New Jersey is applying the New Jersey choice of law rules, chances are the New Jersey court will say that New Jersey law is going to apply if it can, especially if the insured risk is located in New Jersey. If it's located outside of New Jersey and there's a conflict between that state's law and the law where the policyholder is located, more often than not, a New Jersey court is going to say that the law of location of the insured risk will control. Because in the New Jersey court's mind, that state has the dominant significant relationship. So here you've got, three examples of three states applying what they believe to be the same restatement approach, but they come out with wildly different results from on the Connecticut, New Jersey side to the Illinois side. On the Illinois side, if you got a policyholder that's got risks in several states, chances are the Illinois court isn't going to deal with where the risk is located, and it's going to default back to where the policyholder is located. On the flip side, New Jersey and Connecticut, and several other states for that matter, are going to default to where the insured risk is located. And as we'll see, that could mean the difference between winning your case and losing your case. Aside from what we just talked about, There are other approaches. New York, for example, has a center of gravity or grouping of contacts approach, and in my mind, it's very similar to the restatement. They just call it something different. California has a governmental interest approach, which is, again, similar but has different nuances that, we could talk long into the night about. God help you if anybody would want to. So let's just take an example to see how this plays out. So say you've got an Illinois-based policyholder that has worldwide operations, and they have a pollution claim based on a site in New Jersey. And as is often the case, you've got your insurance company that's located in Connecticut. And to add yet another wrinkle, say, although your policyholder is based in Illinois, their broker is in Virginia. It happens. And say on this one, you do have late notice of a full year, which Illinois courts, much to my chagrin, have held will be unreasonably late and can bar coverage. So under this scenario, let's see how it plays out, depending on where you would bring suit. So if you were to bring your suit in Illinois, the Illinois court would apply the Illinois choice of law rules. It would apply the Illinois restatement, or the most significant contacts approach from the restatement. And it would find that Illinois law applies because it's an Illinois-based policyholder. It's not going to focus on the fact that the pollution claim is in New Jersey. It's going to give that one little weight. It's going to hold that because Illinois law applies that the late notice defense is valid and prejudice isn't necessary. So here's a situation where an Illinois policyholder may not want to, take advantage of its home court and may want to bring suit elsewhere. You could also bring suits in Connecticut because that's where the insurer is located. The Connecticut court is going to also apply the most significant relationship test, but hold that New Jersey law applies because that's where the pollution or that's where the site is located. And in that instance, because New Jersey law would apply, it would hold that the late notice defense is valid only if they can show prejudice, a much better result for the policyholder. They could also bring suit in New Jersey because that there's a contact there because that's where the site is. New Jersey law is going to apply its version of the restatement approach and also hold that New Jersey law applies because that's the law where the waste site is. And because New Jersey law applies, the policyholder is in good shape because the insurer will have to demonstrate prejudice to prevail on its late notice defense. Lastly, you can bring suit in Virginia because that's where the broker was located. Now, Virginia is going to apply the traditional lex loci approach, hold that Virginia law controls, and under Virginia law, again, the late notice defense is valid. So you've got 4 forums and 2 different possibilities here. So again, it shows you just how important these considerations are. You pick the wrong forum, you get the wrong choice of law, you get the wrong choice of, or not the wrong choice of law, but a particular type of choice of law rule, it gets you a bad result. I'll give you one more example and then we'll wrap this up. Here's the conditional pollution exclusion example, and this is the one where the policy holder gets a bad result if he has to show a temporal or an abrupt pollution event. Gets a good result if all he has to show is that the pollution was unexpected or unintended. So again, let's say that we've got an Illinois-based policyholder with worldwide operations. This time you've got a claim arising from, say, an underground storage tank that's leaking in Virginia. Once again, you've got a Connecticut-based insurer, but here your policy is delivered to the policyholder's broker in New Jersey. And let's say that your underlying claim is the EPA brings a circle action based on, again, on the leaking underground storage tanks. So this time you bring suit in Illinois, and the Illinois court, again, will apply Illinois law because that's where the policyholder is located. But here you get a favorable result because Illinois is good on this issue. You bring in Connecticut, a Connecticut court would apply Virginia law because that's where the risk is located, and you get a bad result. A New Jersey court would also apply Virginia law because that's where the waste site is located, and again you get a bad result because Virginia law is bad on this issue. And lastly, you can bring it in Virginia, But this time Virginia would apply New Jersey law because that's where the policy was delivered and thus made under their approach, and hold that the pollution exclusion doesn't apply. So again, depending on where you bring your suit can have, and depending on how the courts treat the choice of law issue, it could have wildly different results. Some really good for the policyholder, some really bad. So, what's your takeaway from all this? You've got to identify what state contacts you have. What are your different options for bringing suits? What different laws might apply here? Second, obviously, once you just have that list, take a look at the different choice of law rules for each of those forms. Third, obviously identify the coverage issues that you have. And then fourth, evaluate those coverage issues under the laws of each of the potentially applicable states. Then you'll have basically a matrix and say, okay, well, if I bring suit here, this choice of law rule will apply and I'll get this result, as opposed to I bring suit there, a different choice of law rule will apply, and a different state's law could possibly be applied. So from there, you chart your course and you make the best decisions in order to maximize coverage. So that's all I've got on this issue. I thank you all for your time. If you have particular questions, I'd be more than happy to answer them. But with that, I'll turn it over to, I think, Andrea, who's up next.
Adam, thank you very much. This is Ken. Just want to jump in real quick. I think, first of all, I want to thank you for that presentation. We'll probably take some questions on it a little bit later. Secondly, you should all now be seeing the poll question coming up to make sure that you click to indicate you are paying attention and listening so that you can get your CLE credit. So please go ahead and click on that as soon as you can. And then I will go ahead and introduce our next speaker. Andrea Warren is an associate in our Indianapolis office. Little known fact about Andrea, she is a member of several important organizations, including the Sports Lawyers Association. And in that capacity, she attended the NFL Scouting Combine in Indianapolis earlier this year and posted the 10th fastest 40-yard dash time. Andrea?
Thank you, Ken. I'm just going to be going over 10 tips on securing coverage without litigation. And we will start with tip 1, which is to be prepared. When the big claim hits, you want to be ready. You likely paid hundreds of thousands or millions of dollars for your policies, so at least know where they are. Don't get stuck trying to find your policies after a crisis. This can be a very expensive diversion from the real emergency. Also, understand your policy structure and coverage towers. A lot of clients like maintaining a spreadsheet or a mud map or having your broker do that really captures all of your coverage lines and layers. And then you want to understand when your SIRs and deductibles will come into play. If you're at a risk for long tail claims, consider getting a historical archaeology. In that, Coverage Counsel or certain vendors can reconstruct your historical coverage by going through old policies and evidence of coverage. Also, you'll want to build your relationships with carriers. If you have a risk manager, make sure they attend industry events and know and leverage your purchasing power, even if you don't have a risk manager. Maintaining relationships with your carrier can make a difference, not always, but sometimes. We have a client who has a 30-plus year working relationship with its carrier, and that has allowed it to avoid some of the aggressive pushback you typically encounter from insured. Tip 2 is to get coverage counsel. Coverage claims they're not simple and they're not intuitive. So if it's a big claim, get coverage counsel. Remember that almost every coverage decision that has established the right to recover millions or billions of dollars started as a denial of coverage. So don't be afraid to engage counsel and spend the money on that. And at least get a coverage assessment. You may not spot the coverage case. Coverage is a really nuanced area, so don't rely on your interpretation, your defense counsel's interpretation, or your broker's. We've picked up a lot of coverage cases where other attorneys didn't catch the coverage issue, not because they were acting in bad faith, but because they just didn't catch it. They just weren't familiar with that area of the law, and it could have inadvertently impaired the policyholder's rights under that policy. The benefits of coverage counsel are numerous. We only represent policyholders, we have complete loyalty to policyholders, and we have no actual or business conflicts. We understand the industry, the trends, the key policy language, the forms, the players. We understand the special rules of construction, and we know where to look for waiver and estoppel arguments. We also have nationwide tools and resources where we're in daily contact with policyholder attorneys throughout the nation. Also be cautious of who is giving you coverage advice, especially if it's coming from defense counsel appointed and paid by the carrier. They may not have your back, they may not be able to provide the aggressive advice, and they may actually have a conflict in addressing coverage issues. Tip number 3 is that provide timely notice, as Adam had discussed. It's okay to be vague. It's just preliminary notice of a claim, but be thoughtful with your language. Don't give away or limit coverage based on unnecessary language from a template letter that you have stored. As Adam discussed, it isn't detrimental, but it can be very expensive to undo some of these things. For general liability policies, understand what constitutes a suit. As Adam discussed, this may be more than actual litigation. For D&O policies, understand what constitutes a claim. This may be subpoenas. Understand what your policy defines as a claim. Does it include non-monetary relief? You just have to look at policy language and the case law to make those decisions. And on that note, for D&O policies, you may need to provide notice of potential claims, facts and circumstances that are likely to give rise to claims. When submitting these, consult with your coverage counsel because some jurisdictions do require more specific notice for the facts and circumstances, but also use this as a tool. By providing notice of the facts and circumstances, the eventual claim may be deemed first made during the policy period, regardless of when it is ultimately made. So this can be a big help when your next carrier denies coverage on the basis that you, for example, had prior knowledge of a claim. And then understand which policies have been triggered and which policies you need to provide notice for. Of course, occurrence-based policies are triggered by the happening of the bodily injury or the property damage. So coverage will revert back to that policy that was in effect at that time, even if it was 50 years ago. Claims-made policies, so your D&O, E&O, pollution, legal liability policies, are triggered by the making of a claim against the insured. And you want to consider any retroactive date or extended reporting period. Tip number 4 is to understand the carrier's duties. The duty to defend is the carrier's duty to hire legal counsel to defend its policyholder in underlying suits. This essentially gives the carrier the right to control the defense, and it's triggered when the underlying suit includes one potentially covered allegation. After receiving notice from the policyholder, the carrier then has the duty to conduct an investigation into the coverage possibilities before denying coverage. And in some states, this will extend beyond the allegations in the complaint. And this is sometimes labeled the duty to investigate. If a reasonable investigation would have established the potential for coverage, the carrier may breach its duty to defend by not providing a defense. And then remember, the duty to defend exists to defend the entire suit, even if some allegations are not going to be covered by the policy. You'll want to distinguish this from the right to associate. The right to associate in the defense and settlement is not the right to control the defense. It's just the right to monitor the defense. And if you disagree with a counsel or anyone appointed by the carrier to associate with you in your defense, they don't have the deciding vote or anything. But at the same time, you can't freeze the carrier out. You need to let them take additional depositions or perform additional discovery, all paid for by them, of course. And then the duty to indemnify is the carrier's duty to pay for the policyholder's liability for claims that are actually covered by the policy. And because, as you always hear, the duty to defend is broader than the duty to indemnify, the carrier may have a duty to defend even if there ultimately is no duty to indemnify the policyholder. Then the duty to reimburse, which you may see in D&O policies, that gives the carrier the duty to reimburse defense costs. It's not a duty to defend. The carrier has to reimburse defense costs reasonably related to covered claims, and you may want to watch for allocation provisions because they can be varied. Tip number 5 is to understand the implications of the reservation of rights. After you give notice, the carrier will probably issue a reservation of rights to you. This isn't a denial of coverage. It's a reservation of the rights to deny coverage in the future, though. In most states, the carrier must state each basis for which coverage may be later denied. You want to use these points as a roadmap for your response to the letter, and remember these letters for future waiver and estoppel arguments. You don't want to ignore the reservation of rights. You need to respond to preserve your rights by making either general or specific objections. For some reservations, if you see the purported right to seek reimbursement of the amounts allocable to defending non-covered claims, you should probably object to that specific reservation. And if it's a big enough claim, you may want to press the carrier to provide unqualified coverage for you. Moreover, you want to be cognizant of conflicts that arise from reservation of rights or really anywhere. Generally, as I mentioned, the duty to defend will give the carrier the right to select counsel and control the defense. But when the carrier agrees to defend while also reserving its right to deny coverage at a later time, a conflict may arise. When this occurs, many states will find that the duty to defend transforms into more of an obligation to pay defense costs for independent counsel, usually of the policyholder's choosing. So you may have heard this as cumulative counsel. In some states, the mere issuance of a reservation of rights will create a conflict to justify this independent counsel. In other states, the reservation has to be based on an issue that will be litigated in the underlying action. So, for example, the underlying complaint alleges intentional and negligent conduct. You also want to know that the right to independent counsel will give you full control of the defense, even absent express policy language stating otherwise, because of this conflict. And it's not a duty to reimburse. The carrier should be paying the defense counsel, not reimbursing you for payments that you've made. The sixth tip is to understand the carrier's duty to settle, which this has become a very active issue in very varied throughout the states. Most policies grant the carrier the right to consent to any settlement, but also provide that such a consent cannot be reasonably withheld. If the carrier is being unreasonable in settlement negotiations, you may want to consider teeing this up as your bad faith claim. Document and record everything and be detailed. The carrier generally, even if it's not, of course it won't be in the policy, but has, by case law, the implied covenant or duty to act in good faith toward its policyholders in most states. So carriers that reject or ignore the opportunity to negotiate a settlement within policy limits may breach this duty. And that breach can lead them to be liable for the entire amount of any judgment, including any amounts exceeding policy limits. And vice versa. Carriers may want an immediate settlement that you wouldn't consent to. They still have that duty to act in good faith. They can't subject you to harm. And a breach of the carrier's duty to act in good faith can lead to, it can come through as a breach of contract claim or a tort claim. And at least one recent court, it was actually an Indiana court, found that despite there being no coverage because the insured had made a voluntary payment and nullified its coverage, the policyholder could still potentially recover on its tort claim for bad faith against the carrier. So that was a really good opinion. You want to be strategic about your options. In settlement discussions, policyholders are frequently put into a catch-22. The carrier is unreasonably refusing to settle. You have many options, two of which are you settle anyway, then sue your carrier to recover the costs up through settlement to the policy limits. Or two, you can reject settlement, risk trial, and risk a judgment in excess of policy limits, and then sue your carrier for its limits plus any excess judgment. A lot of policyholders would prefer the first because it avoids a risky judgment. But at least one Georgia court recently found that the second approach is what it wanted to see. It found that a policyholder can't settle and then pursue the carrier for breach of its duty or bad faith. There must be an underlying judgment from an actual trial before it can sue its insurer for any breach of the duty to not give consent where it was necessary and so forth. Of course, if the carrier has denied coverage or effectively failed to defend, the policyholder is free to act on its own, and settlement with a third party can include an assignment of bad faith claims against the carrier. But remember that courts have found that the mere issuance of a reservation of rights itself, that doesn't relieve the policyholder from its obligation to obtain consent to settlement from the carrier. Tip 7 is to be strategic about excess coverage. You want to work with your coverage counsel to present your claim to carriers in an effort to maximize coverage. Avoid forfeiture of excess coverage by settling with lower layer policies. For example, say you settle with your primary carrier for $700,000 on a $1 million primary policy. Can you pay the remaining $300,000 to trigger the excess policy, or must the underlying limits be exhausted solely by actual payments made by the primary carrier on claims? Or, sometimes, maybe rarely, is the excess carrier required to drop down and cover any of the limits? So you want to look at policy language and case law. There's a lot of conflicting decisions that aren't necessarily reconcilable, and make strategic decisions. And as Adam had mentioned before, especially on your long-tail claims, you really want to strategize the exhaustion and allocation among multiple policy periods. You may have the right to choose among 50 years of policies to defend and indemnify your claim. And you want to know which ones to tender notice to and trigger in an effort to avoid deductibles or insolvent carriers that you can avoid if possible. Tip number 8 is to be engaged and cooperative. Be the last email, the last letter, the last call. Keep in mind that the jury may be the next person to see your emails and letters to the carriers. And it can be annoying, but provide requested information and documents when it's reasonable. Don't allow the carrier to use your resistance to avoid coverage or refuse to consent to a settlement. And being engaged in the claims process could be beneficial to you. You know, your carrier doesn't know your industry necessarily. So if you can explain that the exclusion they want to apply would essentially make coverage illusory for you, maybe explain this to them and see if you can get somewhere. And, you know, another thing we've seen that works is if you use real numbers, they can be persuasive. How much premium have you paid in the last 10 years versus claims you've made and anything they've paid? It can be helpful. You also, though, want to understand the bounds of your duty to cooperate. It isn't endless. If your carrier tries to abuse its right by making unreasonably burdensome requests, you want to strategize an appropriate response. Again, don't just ignore it. But obviously, some documents are off limits. Don't lose your attorney-client privilege or anything like that, and always consider a confidentiality agreement with your carrier. Tip 9 is don't get jumped. Bet-the-company coverage litigation exists, and it's winnable. In March 2015, we recently received a $200 million coverage verdict on a summary judgment after 4 years of litigation. So step out of your comfort zone as the corporate defendant and be the aggressive plaintiff. Consider engaging other corporate insureds that may be having similar issues and that you can bounce ideas off of. You also want to anticipate a deck action, have your complaint ready to be filed in a favorable jurisdiction, just as Adam had mentioned. Your carrier can file that deck action while it's supposedly investigating your claim, so just be ready for that. And don't worry, you'll find another carrier to insure you, and your PR is not going to be horrible. You're suing an insurance company after all, so that will be fine. I know a lot of policyholders may be concerned about that. And then be sure to avoid any unwanted arbitration. Some jurisdictions, for example, Georgia, prohibits enforcement of agreements to arbitrate insurance contracts. So if you want to avoid arbitration, and there's a chance you're going to be subjected to it, then consider filing one of these jurisdictions if you can. Finally, tip 10 is to learn from your experiences. You want to strategize renewal with coverage counsel, get involved in the renewal negotiations. You know your business better than anyone, so negotiate favorable language in your renewals. You know, do you want the right to control defense and settlement? Do you want the right to use your preferred lawyers, the right to consent to settlement? Do you need the ability to add additional insureds without carrier approval? There's so many things that you can negotiate and potentially get in your policies that will avoid disputes in the future or at least minimize them. And finally, you'll want to consider emerging risks when you're in your renewal negotiations. The principles that we've discussed today apply generally across the board. So keep those in mind when you're thinking about the emerging risks. And they can be anything from cloud computing and digital slander to concussions and e-cigs to air pollution and genetic testing. It can go on and on and on. So thank you for your time, and I'm willing to answer any questions now or after Kara presents.
Thanks, Andrea. That was terrific. And don't see any questions coming in from our audience right now, though I imagine we'll have some a little bit later. But right now, for our listeners, please look up at your screen and see once again we have the CLE attendance poll. Last time we got not nearly everybody who is logged in confirming their attendance. So if you are away from your computer, please look up, go over to your computer, click yes. I don't think that anyone wants to click no. That's not going to help you. You want to click yes, indicating that you are attending this webinar, and then it will get you your CLE credit. Very good, everyone. All right, so our next speaker, Kara Cleary, in our Atlanta office, actually originally used to work in our Indianapolis office, but she was traded from Indianapolis to Atlanta for 3 first-round picks. Kara?
Thanks, Ken. Good afternoon, everyone. My portion of the presentation is going to focus on strategies for creating a risk-reducing organization, and then to tag on to Andrea's presentation, I'm going to then discuss tips for litigating insurance coverage issues. If you weren't successful in trying to avoid litigation, these tips will hopefully help you navigate once litigation happens. As Ken mentioned, I'm an associate in the Atlanta office. I've been practicing on the insurance coverage side of things almost primarily for the last 4 years. I also have experience in general litigation and still work in that area as well. But I'm happy to speak with everyone this afternoon. Okay, let's jump in. So first, you want to think about general strategies for reducing risk. And every organization is faced with these issues, and they're constantly evolving. And so these tips are not a one-time task. These are tips that you should be doing at least on an annual basis, because there's different trends that arise, there's different coverage issues that may change once the insurance industry reacts. For example, right now, cyber insurance is all the rage, and so we're going to see a lot of change in that area as well. And so things that you may have to watch out for now on that area may be different in 6 months from now. So when you're thinking about your risk as an organization, it's an evolving process. And so one tip that we often recommend to clients is to actually create a checklist. And by looking at and thinking about where your risk is as a corporation, it's a very worthwhile exercise, because it'll make you think about the issues that you already know about. It will help you think about areas where you see there's a potential where you might not have had a claim yet come in, but you know that there maybe are better practices that your company could be following. And so by creating this checklist and making you think about the what if, you'll have a list that you can work from and expand on year to year. And then it's also a great opportunity when you have your year end or you're at a renewal and you're looking at your claims history, compare what actual claims you had versus what was on your checklist. And that will be a good indicator of whether you're evaluating your risk properly. The next big area where we see issues arise with our clients is making sure that people in your organization know who to talk to if they receive a claim, or, for example, if you are a corporation that has an environmental department that may be getting letters from the EPA, make sure they know who their risk department is. And if you don't have a risk department, if it's in-house counsel that should be getting notified of these potential issues, you want to make sure to educate your organization. That way, when there is a claim or there's something that's going wrong, people know who to report to. And then that next issue is to provide notice of potential claim early and often. And again, you want to educate everyone in your organization about what a claim is. As both Adam and Andrea talked about earlier today, it depends on your policy language. It depends on the different policies you have. And so, other people in your organization might not know that an EPA letter could constitute a claim, or that a subpoena could constitute a claim. So you want to make sure that all of the channels of communication are open in your organization and that people know who to talk to so that these things don't fall through the cracks. Another issue is that this is where Coverage Counsel can really help. If you're not sure whether something would really constitute a claim, we can help with that. We can also help navigate if you have a large insurance program with different types of policies. We can help you analyze which lines of coverage should be noticed. That is not an easy task to do, and that's an area where, oftentimes we see clients maybe provide notice under one policy, but they didn't realize that these other policies in their program also could have provided coverage, and then you run into a late notice issue down the line. So whenever you get a claim, you want to be sure that you're analyzing all potential for coverage and getting your carrier's notice timely. Oftentimes, we have clients that may rely on their brokers to provide notice. We want to make sure that you're following up with your broker to make sure that notice was actually provided, and you want to make sure that it's getting to the carrier. Okay, other general considerations. You want to properly maintain your insurance records, and this includes policies. I think Andrea mentioned earlier today the difference between a claims-made policy and an occurrence policy. Well, occurrence policies don't ever expire, so there's no good time to get rid of occurrence policies. You want to have those around. For example, you can collect on policies that are from the 1950s if you have a long-tail environmental or asbestos claim. And so this can become very burdensome when you have people transitioning in and out of risk departments, or you are a company that acquires other companies, and so you want to make sure that you have a handle on all the coverage that may be available to you and understand that this could go back to the 40s, 50s, and current. And so you want to, if you haven't already have a good organization of your insurance records, that's a worthwhile exercise to do. Oftentimes we recommend that clients with large insurance programs create coverage charts. That's something that we can help with. That's also something that a lot of different vendors can create. And it's nice to have that constant visual reminder of the different layers, the different carriers. You can color code them to mark which ones may be insolvent. And that will be a good visual for you to understand the limits and coverage towers that are available so that when you have a claim come in, you literally have a full picture in front of you of who possibly may get notice and where you could find coverage. Okay. Next, you want to try to create best practices within your organization. Again, this kind of goes back to your risk mitigation checklist. You want to think about the areas that expose you to the most risk. So if that's, your contract relationships, you want to make sure that you have best practices set forth in your organization for contract language, what you'll agree to, what you won't agree to. If you're a company that has lots of acquisitions, you want to make sure that you're ensuring that transfer of insurance rights and different things like that are being taken care of properly. If you're a company that has cyber potential, you want to make sure that you have that protection in place and understand the risks that are involved with that. So again, you want to identify the areas where you're going to have risk as an organization and then try to create best practices to avoid that. And then next, you want to treat the renewal process as an opportunity. Oftentimes when it's time for renewal, companies are either pressured because there's not a lot of time to analyze it, or they have cost pressure coming down, and it is oftentimes overlooked. This is a great time to, again, look back at your claims history and see, are we getting coverage for the claims that we're getting? And if you're not, then you need to get other coverage in place. And again, this is an area where Coverage Counsel can help you do that analysis. It's not just in litigation where we can give that advice. You want to also think about what's important to your organization. Is it that you want to hit certain limits? Is it that you want to keep a deductible low? Is it the cost issues? Is it that you have a relationship with a certain carrier and you want to keep that going? Is it because you have very high concerns about wanting to be able to choose your counsel if you're in litigation frequently? So again, the renewal process shouldn't be looked at as a burden. It should be looked at as an opportunity to make sure that your coverage is consistent with your risk. Okay, let's turn now to contractual issues. In the insurance industry, we often see a lot of problems with different insurance issues based on contracting. And so again, as we talked about earlier, one idea for a best practice is to create must-have clauses. And this is pre-approved language already within your organization that people can use in contracts. And not only do you want to take the time and effort to create those clauses, but then you need to also make sure that that is being circulated within your organization and ensure that people are actually using them. Another issue that we see is oftentimes in deals, there's a lot of forms that are being used. And unfortunately, the insurance industry is constantly changing, and so some of the forms don't keep up with the insurance industry. And so we often see a lot of disconnects between contract forms that are being used and issues in insurance, and that creates a problem down the road if you have a coverage claim. You want to make sure that you understand the basics. What type of insurance do you need? There's different types of coverage out there. You have your CGL policies, your professional liability policies, your media policies, your D&O, your E&O. You can have the highest limits in the world, but if it's not the right type of coverage, it doesn't matter. It's worthless. And so you want to make sure you're understanding what type of coverage is necessary. You also want to make sure you understand what types of limits are available. Oftentimes, different coverage parts within a policy have different limits. You want to make sure you're aware of that. You also want to make sure that you understand how your policies work, or if there's other coverage available. There's often provisions in your policies that will impact your limits if there's other coverage available. And so you can't just take face value the limits on your deck page. You have to make sure you understand how those are going to play out. And then you have to make sure you understand how long coverage is going to be available. Do you have claims-made policies? Do you have occurrence policies? It's a lot of details to keep track of, but it's extremely important so that when you do have a claim and you need to rely on that coverage, what you thought is going to be there is actually there. Another area is the additional insured status. A lot of times in your organization, I'm sure you've been asked to either be an additional insured on someone else's policy, or you've required that of your subcontractors or vendors. And this is an area where, again, you see a lot of forms. There's a lot of bad practice where people will just give a certificate of insurance. It's not enough. The Insurance Services Office, or the ISO, which you may have heard of, has over 31 forms for additional insured. That's a lot. And so you can't just rely on a certificate of insurance. You should always try to ask for the endorsement and the policy if you have required that you're an additional insured, to make sure that the coverage you're expecting is actually there. There's other issues too. For example, as an additional insured, are you going to have to pay a deductible? Again, you may not know that just from the certificate of insurance that was provided to you. Do you have coverage for your own negligence? A lot of times it may be limited to your contract between the parties, and so it's state-specific as well. So you need to be aware, whether you are giving additional insured status or asking for it, that you understand what coverage is actually in place. The next issue is efforts to try to limit your liability costs. So two big areas where we see this is exclusions of warranty and limitations of liability provisions. Both of these, again, can be state-specific, and so going back to the importance of choice of law. With regard to warranty, there's a requirement that you have to exclude express warranties. UCC 2316 is a provision. It allows the exclusion of implied warranty of merchantability, but it must mention merchantability and must be conspicuous. And the exclusion of implied warranty of fitness must also be in writing and must be conspicuous. So you have to use language such as is or with all faults, and you have to be very cognizant that if your intent is to exclude express warranties, that you're doing it properly in your contracts. Next, with limitations of liability provisions, again, this varies greatly state by state, and it is going to depend on the type of contract and the bargaining power of the parties. You have to be cognizant of what state you're in and what state law is going to apply. Some are per se unenforceable depending on your state. So again, you have to make sure that the intent lines up with what is actually going to occur if the contract goes bad. The next area is the transfer of insurance rights in corporate transactions. And the general rule is that an asset purchaser doesn't automatically inherit the seller's liability. However, the caveat to that is unless successor liability is a matter of law. And so you see this in a couple different areas. Where this turns into an insurance issue is you want to make sure that if you are inheriting the seller's liability, that you're also inheriting their insurance that they had in place. And so oftentimes what we see is in deals, insurance issues are not always on the front burner. A lot of times there's a closing deadline, and so it's not until you're trying to close the deal that the insurance comes up. And unfortunately, that can be too late. You really want to try to keep in mind whenever you're doing a corporate deal and you're going through the due diligence process, don't forget about insurance issues. Try to get those identified early so that if there are problems or areas where you need more counsel or an opinion on, you have time to do that without holding up the deal. You know, we understand that when things are trying to close, that's the push, that's the goal. But unfortunately, your deal may not be as worthwhile if you're faced with a lot of liability and there's no insurance for it. So when we look at successor liability as a matter of law, it happens in these four situations. When there's a consolidation or a merger, and that's, as stated, just the type of transaction it is versus an asset purchase, where it's mere continuation, and that analysis is the transaction basically a de facto merger? Is it the same management, the same shareholders, the same business line? That would be considered a mere continuation. The next is fraudulent purpose, and for that you want to ask, was the transaction done just to escape liability? And if that's the case, the insurance company can deny coverage and the policy can be voided. And most states have enacted the Uniform Fraudulent Transfer Act, and that act sets forth the various factors that courts may look at to determine whether it was a fraudulent purpose. The last one is product line. And this one is not recognized by most states. It's a little bit outdated. The purpose was originally to protect claimants in a situation where the original manufacturer no longer existed. And the product line can be avoided if the predecessor keeps some of the assets that were involved. So again, this is just to give you an example of some of the situations where, as a successor, you may be found to have liability as a matter of law, and in those situations you want to make sure that you have the insurance to go with that. There are a majority rule and a minority rule, and a lot of times in your insurance policy there is a consent requirement that you cannot transfer the insurance rights to another entity unless you have consent of the insurer. And so this is a big area where you get into claims and you have this transfer of rights, and the new acquiring company wants to make a claim on that older insurance policy. And so the insurance company may come back and say, hey, you never asked us for consent and you violated this provision in our policy, so we are not going to provide coverage. So again, this goes back to the choice of law, whether you're in a majority state or a minority state. The majority state says, you know, look, the intent is it's a pre-closing occurrence. It should go with the insurance policies. The right and liability should stay together, and we're not going to require insurer consent, so you can still proceed with this claim. The minority rule, however, requires insurer consent. Now, if you have a minority state law that's going to apply, some workarounds are that you can try to request indemnification in your contract, but again, that's sort of a last workaround step. You want to try to get ahead of it and make sure that you are on top of the insurance issues and working around these issues so that you make sure you have access to the insurance coverage. There's also been a lot of case law on these issues, and recently the Delaware Supreme Court came out with a decision that held that a dissolved corporation can still have claims brought against it since it has insurance. And we often see that a lot of companies are made in Delaware, and so this was a big coverage impacting decision that came out. The case was Anderson versus Kraft Murphy, and it's important because you have to understand that even if you've acquired a company that has since been dissolved, claims can still be made against that company. And so it's just a reminder that you have to be cognizant of these insurance issues anytime that you're dealing with an acquisition. There's also a recent trend in the industry where reps and warranty insurance is available. This is something that should be carefully considered depending on your transaction. It can be costly, but it does serve to provide a little bit more security to make sure that what's being represented during the due diligence is actually upheld. So again, this is an area where coverage counsel can really help you navigate those waters. Okay, now let's turn to the next segment of my presentation, which is tips for when you're actually litigating insurance claims. And so before you start any litigation, there's some initial things that you need to do. And the first is to re-review the denial letter and confirm that litigation is the best strategy. You know, oftentimes we have clients that are very frustrated with their carrier because they're disappointed that they've had a long relationship and a claim comes in and they get that reservation of rights letter or denial letter and they're disappointed and emotions may take over and they may want to pursue litigation. It's always a good time before you take that step to re-review the denial letter, re-review the coverage issues, make sure that you feel confident in the positions that you're going to take, budget what you think litigation is going to cost, and make sure everyone's on board within your organization. Also, this is a good time to maybe take that last effort with your carrier to see if you can negotiate some sort of resolution. But again, these are initial steps that you want to do just to make sure that litigation is the best choice, notwithstanding, oftentimes the emotional reaction that comes with that. Next, you want to confirm that notice was provided to the carrier. As Adam, really focused on in the beginning, late notice can be a killer for litigation. You don't want to be surprised once you've taken the time and money to start litigation that you have a late notice problem and that you're in a state that it's bad for you. And so you always want to go back and make sure that notice was provided, and so you know what you're dealing with. If you have a late notice issue, that's not the end-all be-all. You just need to do the choice of law analysis that Adam talked about earlier and make sure you file so that you have a good state law applied to your late notice problem. Next, if you are going to have a bad faith claim against your carrier, you need to make sure that you've met any statutory notice requirement. For example, here in Georgia, we have a statute that requires you to make a demand on your insurance company and give them 60 days to pay that demand before you can bring a bad faith claim. And so you don't want to get into a situation where you're either trying to file quickly or respond to a deck action that your insurance company has filed when you haven't given all of your notices. So again, if you have a bad faith claim, make sure you've met any state's requirements for statutory notice. The next is statute of limitations. Similarly, you don't want to take the time and money to file a suit if you have statute of limitation problems. And so not only do you want to check your general breach of contract limitations in that state, but you also want to make sure that your policy may have a claim limitation period in there, so you want to make sure you're aware of that and you're complying with that as well. And then finally, you need to consider whether any other parties should be brought into the litigation, and sometimes that may be your broker if there's negligence. We see this sometimes where there's a late notice issue where a broker didn't provide timely notice, or if coverage was not bound properly. Again, this is a sensitive area because a lot of times clients have long-standing relationships with their brokers, and so it's an important consideration, and it's one that should be thought through very carefully. Okay, so once you've gone through those initial tasks and you still decide that litigation is the right path for you, the first thing that you need to do is pick your forum. And again, this is one of the most important decisions that you're going to make, and it's a decision that you should have already thought about well in advance of drafting your complaint. As Adam spoke to you earlier today, choice of law is critical to insurance coverage disputes. I mean, your case can rise and fall on choice of law, and so you need to make sure you're doing that analysis. It's cumbersome, but the matrix is a great idea. We do it all the time. And it's a work product that you can use over and over again as well and build off of, and it really helps put these issues in perspective. And, it's hard because you're going to likely have several coverage issues, and there may not be favorable result on all of them, but you need to understand which ones are case killers and try to avoid bad law on those issues. and also understand that your insurance company is doing the same matrix, and they're thinking about where to file so that they have the opposite law apply on those key issues. And so you need to be aware of the full picture of your different states that may apply in their law on these critical coverage issues. Next, you need to think about your state court versus federal court considerations. Again, this is going to be very jurisdiction dependent and state dependent. You want to reach out to coverage counsel who may have some insights. You may want to talk to other colleagues, look at published opinions. State courts sometimes may be more favorable to policyholders. Usually, if you file in state court, the insurance company is going to try to remove to federal court. So there's a lot of tactics involved, but you just want to think through those. And as the policyholder, you want to try to file in the most favorable jurisdiction for you and then deal with any efforts to change that venue as they come. Lastly, you want to research your assigned judge. You want to look at published opinions that judge has issued on insurance coverage. A lot of times, you'll see trends with certain judges. That doesn't mean that that's going to happen in your case, but you want to have all the intelligence that you can on those issues. Okay, next is preparing for discovery. A lot of times the underlying claim that you're having a coverage dispute about is very robust. If it's a long tail claim, it's historical in nature. It takes a lot of time to collect and organize the data. It takes a lot of time to identify witnesses, and sometimes those witnesses may no longer be employed with your company. So the sooner you can do these efforts, the better. We recommend a database. We have a client that had 20 plus environmental sites, and so we decided to put together a database where for each site we could have the policies, the site information, the remediation that was done, the cost that was spent for those sites to help collate all of that information. And so this is very time consuming and expensive, and you don't want to wait until you're served with discovery and have 33 days to deal with it. You want to get ahead of it. So if you're going to go into litigation, getting a handle on the discovery issues is critical. Another problem that you need to be prepared for is early motion practice. This is a tactic that we often see insurance companies use. They will file removal actions, they will file a motion to dismiss, they may file a motion to compel arbitration, and in some cases we've seen all three of those. And so they oftentimes are very aggressive out the gate, and this is problemsome for the policyholder because it's very expensive early on in the litigation. And so we always try to prepare our clients for this and make sure their budget is prepared so that you don't fall victim to this tactic. Going back to some of the discovery issues, we have frequently seen carriers push back on producing their entire claim file, on producing reserve information. They come back with 50-page privilege logs, and so you don't want to be scared by that. You want to carefully examine their designations. With reserve information, you're certainly entitled to that, especially if you have a bad faith claim. And so these are areas where, we often see, but we can navigate. A lot of times the insurance company will retain coverage counsel, and then they'll try to protect most of their claims file as attorney-client privilege. And so we have experience in, disputing those types of claims and really boiling down when litigation was anticipated. So they will try to withhold a lot of information, but don't let that stop you from pushing on the discovery that you're rightfully entitled to. And I'm going to quickly go through the next two slides so we leave time for questions. Some final thoughts. If you have an underlying lawsuit that is also being litigated at the same time as your coverage case, that can be problematic. A lot of times it's a good tactic because it'll keep pressure on your carrier to try to accept coverage. But another way, it can also air the dirty laundry in front of the underlying claimants. And so, for example, you may have a claim where the underlying claim has a lot of discovery and you don't want them to see your coverage dispute. You don't want them to see your broker communications. And so you have to carefully analyze whether you should request a stay, or whether you should, dismiss your case without prejudice and try to enter into some tolling agreement with your carrier until the underlying claim is resolved. So it's just another issue to be cognizant of. It may not be the best idea to have your coverage case going at the same time as the underlying claim. And then finally, a roadmap to settlement. Oftentimes in coverage litigation, it feels like the insurance company, even though they're the defendant, is kind of taking the lead in the litigation. You get the early motion practice that we talked about, you get the early discovery disputes that we talked about, and it can be a little frustrating for a policyholder client, especially when you're paying high legal bills. However, we start to see a tide turn once we get to the depositions, typically the 30B6 of the claims and underwriting depositions. That's where, in most cases, you really see a change in tone. We recommend that we have our clients present, especially at the underwriting 30B6 deposition, since that's typically the person that has the client relationship, and has, their job is to bring in business and keep policyholders, and so we have found that to be very effective. So just understand that it may be a tough road to get to discovering depositions, but that's often a time in the case where it starts to turn in your favor. Same with summary judgment. They are critical. It is costly to get those put together, but most of our cases settle while summary judgment motions are pending, and mediation is required. Again, mediations in our experience, we see them slow to start. They typically don't settle the day of mediation, but if you have a good mediator, they'll help close the gap, and most of our cases settle. And lastly, remember your points of leverage. Andrea talked about this a little bit earlier today too, but you want to tap into your relationship if you have a long-standing relationship with your carrier and play that business card. If your broker has a good relationship with the carrier, you want to leverage your broker's relationship. If it's close to renewal, that is an excellent time to try to leverage your business if you have a current coverage claim issue. And again, you want to make sure that those underwriters are aware of that. And finally, insurance companies try to avoid trial. And so even though coverage litigation may be costly, we see it settle. And for example, I've been doing this 4 years, I haven't had a trial yet. So again, these are, it can be tough and expensive to get there, but ultimately, in our experience, it's successful. So with that, I'm going to wrap up. Thank you for listening, and I'm happy to answer any questions, and I think Ken will probably open it up to all the speakers as well for questions.
Thank you very much, Kara, and thanks to all of our speakers. So first of all, we have a question that came in. Kara, what are the must-have clauses that you recommend?
So that's a great question, and unfortunately, it's a hard one to answer because it depends on your company. It depends on the type of contract. Again, that's an area where we can help advise you if you have a specific contract, but you want to make sure that you are, we see this often in additional insured context, and so you want to make sure you have the right form applied and that you also understand the coverage that you're giving and requesting. And then again, with deals and contracts and those contexts, you want to make sure that you're not using those outdated forms. So unfortunately, it's not really a question that I can give you a specific answer, but just identifying contract issues that you've had problems with in the past is probably the first step, and then working to amend that language to avoid that risk again.
Terrific. And to our audience, please continue to fire in your questions in the Q&A box. In the meantime, I've got a question I want to throw out kind of to the group here, any or all of you. I know that in our practice we see notice letters that are drafted by our clients, that are drafted by brokers, that sometimes are drafted by our colleagues throughout the firm or even ourselves. And in that realm, I think we probably all see at least two different species of notice letters. There's one that simply says, we've been sued, here's a copy of the complaint, please defend us and indemnify us. And then there's another school of thought that says, I'm going to write a very detailed notice letter that's essentially going to argue all of my coverage issues so that right off the bat I'm starting to persuade the insurance company in favor of coverage. So to the group, do you have any preferences for either of those approaches or somewhere in the middle?
It's Adam. I'll take the first stab of this. I fall into the first camp. I like the less is more approach. I mean, you're dealing with insurance companies that are sophisticated, so don't think that just because you write an impassioned notice letter that's going to sway anybody. They're going to take a look at the complaint. They're going to take a look at the policy. They're going to make their own determination. So in my mind, let the complaint speak for itself. I basically send a letter that says, "Dear carrier, we represent so-and-so. Please be advised of the matter of being pursued against so-and-so, and we look to you to honor your obligations to provide indemnity and defense." And let it go at that. Let the carrier get out in front and take a position, and then you've got a target to shoot at, rather than you being the target by laying out all the positions that you have at the initial stage. They will provide you with an initial acknowledgement letter, then they will provide you with their analysis, chapter and verse as to why or why not it's covered, and then you can take it from there. That's my approach.
Thanks, Adam. We have another question that came in from the audience. How do we argue with a carrier as to what is considered reasonable attorney's fees for defense? And again, I can throw that out to the group.
I can handle that one initially too, and then I welcome anybody else to chime in. Oftentimes in Illinois, we are confronted with this situation, especially when we're dealing with our right to independent counsel. And the law is developed pretty nicely here in Illinois that says that whatever the policyholder is willing to pay its own counsel without any realistic expectation of reimbursement from a carrier, that's not just evidence of the market rate and what's reasonable. That is the market rate, and that is reasonable. So if you can demonstrate that you've been paying these fees to your counsel in matters that weren't subject to insurance, that's going to be incredibly great evidence for you to show that it's reasonable and should be paid. And even if there is some expectation, maybe you've got of coverage, maybe you're paying a deductible of $100,000 or $200,000 or even $50,000, and you know that you're not going to get that money back, that also can be evidence just by you paying that money that it's reasonable. Of course, you're going to look to, who's defending the case for you? What kind of experience do they have? What kind of case is it? What other rates are available in the market? Those are all going to go into it, but that's a more traditional type of analysis. I think that your best evidence is, these are our guys. We've used them in the past. We pay their rates, and just because of that, it's per se reasonable.
Yeah, and I agree with that. This is Kara, and I just want to add on to that. Oftentimes, depending on the type of claim and whether it's a bet-the-company claim or whether it's a claim for a high-ranking person in your organization, cost doesn't necessarily always drive who you want defending. And so, again, that's just a business decision that you have to think about. Even though the rates may not be deemed reasonable ultimately and you may have to pay the delta for those fees, you want to make sure that you are analyzing kind of the type of claim and what's at stake in conjunction with what the case law and opportunities are for you to regain your reasonable fees.
Great. Now, that is a subject, of course, and so many of the subjects that we've touched on today are almost worthy of full hour or 2-hour seminars themselves, and I know that many of the comments that you've all made today have been general propositions that can have some important nuances from state to state, etc. I think that we're getting some more questions that are in that realm, but I don't want to get us bogged down into that area. So I want to kind of shift gears for a second and ask another question for the group about reservation of rights letters. I think it was during Andrea's presentation that she mentioned that they will frequently include some questions that are put to the policyholder about the claim. And Andrea made the general comment that no one would disagree with, that you should comply with reasonable requests. Many of us, of course, have seen some of these letters. They'll have something like 20 questions. It's as detailed as the interrogatories you're going to get from another party in litigation. So what's your thought on the extent to which you work with your client to answer those questions, and especially in the situation where you're getting multiple reservation of rights letters from multiple carriers all on the same claim?
Well, this is Andrea, and I would just say I normally look at what, especially for example, if it's an environmental claim, what's already public information, and I make sure not to, outside of that, provide anything that may jeopardize an attorney-client provision. And like I said, or attorney-client protection, sorry, I wouldn't provide anything maybe without a confidentiality agreement that may breach certain of those areas.
Another tactic that we've used in some of those situations is, again, try to point to what's public information, try to get what you can easily, and then for those requests that are going to be unduly burdensome, like is it going to require you to pull 30 boxes from off-site storage and weed through that, we typically try to put in the response that, this is unreasonable or burdensome because of these reasons, A, B, C, and let them push back, but at the same time you're kind of preserving your objection and stating the grounds for why it's unreasonable, so that you have some added layer of protection in there as well. So you're responding but giving a non-responsive for some of those issues that are really going to be burdensome.
I'll add from my own perspective a couple of the things that I try to do is, first of all, especially if I'm going to have multiple carriers firing these questions, I try to make one response to all of them. So I'll try to sort of gather up all of the questions and make sure that I'm responding, in fact, not just at the same time, but the exact same letter to every one of them, copying them all so they all have the same information. And another thing that I will frequently try to do is limit how much I put in writing and instead have conference calls or meetings where we share information a little bit more freely, perhaps, under a confidentiality agreement, but we're not putting things in writing that are so easily potentially discoverable by an adverse party, and also not as much creating a record that perhaps the insurance company might even use against us. So it's all a matter of documenting a pattern of cooperating with the carriers, but still controlling that flow of information on behalf of the policyholder client. So we're only getting a couple of more questions. I think just to wrap things up, there's only one other area that I thought would be worth everyone commenting on briefly. We've talked a lot about litigation scenarios, non-litigated claim scenarios, and there was a little bit of discussion also about renewals and applications and everything. So if you could each maybe take just a minute and briefly describe some of the kinds of things that you get involved in on the front end when there isn't a problem, whether it's in policy placement or counseling clients on contracts that have insurance issues. So very briefly, I'll start with Kara and work my way back.
Thanks, Ken. Yeah, as I mentioned before, I think the most common problem we see is that a lot of times corporations don't have a lot of time during the renewal process, or there's cost limitations that are coming down, and we understand that, but understand that there's still room to work, and you can try to negotiate with different carriers. A lot of times, underwriters are trying to market just like all other types of sales, and so there's room to negotiate. So even if you're facing cost constraints, using the renewal process to really make sure you have coverage that's addressing the claims that you're getting, or other issues that you've been facing with your carrier, it's the best time to do it.
Andrea, you want to talk a little bit about some of the non-claim or non-litigation types of things that you've worked on?
Sure. The two areas that I see it most would be, without any claim being involved, would be when an acquisition is happening and you want the company that's going to be acquired, the acquiring company may come to us and ask for an evaluation of coverage or potential liability that may be tagging along. And then the second issue is during renewals, a lot of companies, like Kara said, don't have time or experience or the desire necessarily to go through and find favorable or unfavorable provisions as it relates specifically to their business. So what they'll do is they'll come in and explain their business and explain, maybe any budget that they have that they want to spend on insurance or what their desires generally have been over the years, and we will kind of match that up with provisions that we have. We have a running spreadsheet of favorable provisions and how we can tweak them and negotiate with insurers on them. And we kind of just match those up and expand what they thought may not have existed or that could be beneficial to their company based on hypotheticals and past practices and experiences that they've had.
Terrific. Adam, you want to give us a few more
comments? I'll just kind of expand on what Andrew was saying. In my mind, renewal time is a great time for you. You're buying a product. It's a very valuable product, and chances are it's going to be a very expensive product. Not unlike buying a car or buying a house or buying, a fancy new appliance. Would you go into that kind of process and not shop around? Would you not comparison shop? Would you not try and look at all the different options that are available to you and choose the right one? If you're buying a house, you certainly wouldn't, or a car, you certainly wouldn't, and it's no different when you're buying an insurance product. There's lots of different carriers out there. There's lots of different forms out there. There's lots of different provisions out there that an underwriter can make available to you, some of which are going to be really good for you, some of which aren't going to be so good for you. So, you're spending a lot of money on a policy that could provide invaluable coverage to you, so it's incumbent on you to figure out, what's out there and what best suits your needs. So look at it. I know it's a pain, and I know that's it's a big fire drill when it comes right down to it, but it's important enough to, if you're going to do it, you got to do it right. So, take the time and invest what money is necessary to make sure that you know what the landscape is and what's out there. So, you do the best job that you can do so that if and when the time comes to make a claim, you put yourself in the best position to recover.
Yeah, I think that also speaks to the value for any company of having the risk management department and the legal department work as partners. And unfortunately, there are a lot of companies where we don't see that dynamic, and I think we would probably all advocate that they try to do a better job of working together. So I want to take a moment again to thank all three of our speakers today. You did a fantastic job, and I also want to thank, of course, our audience. We're very appreciative of your time this afternoon. And if you have further questions, I know we were not able to get to everyone. Please feel free to send them in by email to any of the speakers individually, to me, or to our marketing department in response to the email that you will get. And we also would really appreciate, again, if you would respond to the survey that will be accompanied there. And in short order, you all get your CLA too. So once again, thank you, and please look forward to another one of our seminars or webinars within the next couple of months.
All right, thanks, everybody.